Hello and welcome to this month's episode of The Legal Scoop. I'm your host, Brendan Shannon, and I'm an associate attorney here at LOMAD. If you're new to the series, this is our webinar series where we discuss recent case law coming down from either the Third Department or the Court of Appeals. Obviously, that's kind of a constant flow of cases, and they're extremely important to practicing in workers' comp, or just being a claims professional in workers' comp. So we try and stay on the cutting edge with that stuff. And this month I want to talk about the Coyle case. It's Coyle v. W&W Steel Erectors LLC, which came down in May. And this is a case that I discussed in detail with my colleague James Cousins, and we were both pretty annoyed with this decision, and I think you'll see why. So I wrote down some of the facts here because it is kind of fact specific, but the carrier in this case was paying benefits to the claimant's son because the claimant had died for reasons unrelated to the workers' comp claim, but had unpaid, I believe, permanency benefits that were not paid in life. Now, those of you who follow along with this stuff might remember that there was a case back in 2020 from the Third Department, the Green case, where it was held that those types of benefits can be paid. Basically, if a claimant has unpaid PPD benefits in life, they can be paid out to a beneficiary of the claimant. And, there's certain considerations that need to be made to determine whether someone is authorized to collect benefits as a beneficiary, but we won't get into that today. So that was the law of the land when this when the carrier was found liable for paying benefits to the claimant's son for unpaid benefits in life. So they didn't appeal it. If they were to appeal it, it would have been frivolous, right? Later, that exact Green case, the one from 2020, which said that these types of benefits are payable to a beneficiary, was reversed by the Court of Appeals. And it was reversed in, I believe, 2022. After the Court of Appeals decision overturned the decision that said that benefits are payable to a beneficiary for unpaid permanency benefits in life, the carrier in this case filed a motion or an application, if you will, to rehear or reconsider the issue. And the board rejected it, and the Third Department agreed with the board under an abuse of discretion standard of review, basically saying, well, you didn't appeal it in the first instance, so you don't have the right to suddenly raise the issue again because there's been no new evidence or anything like that to support reconsideration or rehearing. However, the Third Department got this wrong because if you look, if they had appealed it in the first instance, they would have been filing a frivolous appeal. They could have been fined for that appeal. The appeal would have been basically filed to take the position that, the board should use its Section 123 jurisdiction to not allow these benefits to go forward to the beneficiary. Basically, no carrier would do that. There could be a situation where a carrier or a self-insured employer would be willing to run that risk so that it can be brought up to the Court of Appeals, but it's very unlikely. So this is a very frustrating decision by the Third Department because basically it ignores the fact that the underlying appeal would have been frivolous, and it actually couches its decision to approve the denial of the reconsideration request or rehearing request on the fact that the carrier didn't file a frivolous appeal. So now there's a carrier out there somewhere who's paying benefits that are not legally permitted. It's just how it is. So that's all we've got for this month. Thank you so much for being here. If you enjoyed the content, please subscribe below. We've got lots of other video series here at LOMAD. We'll be back next month to discuss hopefully a less frustrating decision from the Third Department.